A very, very warm welcome to everyone. Good morning. Is it too late to say Happy New Year? Perhaps not. Happy New Year, if not. Thank you so much for joining this webinar hosted by Landmark Chambers. It's designed to be a quick recap of some of the key planning cases of 2022. And we will also mention some of the significant cases which we expect to see on the horizon in 2023. My name is Matthew Fraser, and I'm joined by Isabella Buono. We are both barristers at Landmark Chambers, specialising in planning and environmental law. It's fair to say that the planning court has been extremely busy in the past year, and inevitably we've had to be quite selective as to what we talk about. And this means also that we won't be able to go into any of the finer details of the cases we're discussing, but hopefully it's nonetheless sufficient to give you something of an overview about what has gone on in the last 12 months and what is yet to come. What we're going to do is alternate as we go through, so feel free to ask any questions, or indeed answer any questions in the Q&A box at the top or the bottom of your screen. If you'd like to remain anonymous when asking a question, that's possible, you can do that, but please make sure that you tick the send anonymously box before submitting your question. And we're going to try and answer them at the end if there's time, and of course we know the answer. Do feel free to get in touch with us by email if there's anything we don't manage to cover. And a few other housekeeping points before we start. Your microphones are automatically muted, so you will not need to adjust your local settings. And also this webinar is being recorded, and you'll receive a link to the presentation and the recording shortly after the webinar has concluded. If your connection is lost at any point during the webinar, we invite you to simply rejoin the meeting by clicking on the same original link as you did before. So with that introduction out of the way, we're going to start with two planning cases, the only two planning cases to have been determined by the Supreme Court last year. Firstly, the case of Hillside, which will, I'm sure, need no introduction to planning lawyers. And then secondly, DB Symmetry. So Isabella, I'm going to welcome you to take us through the first case of Hillside.
Thanks, Matthew, and I'm going to say Happy New Year as well. So starting with Hillside, which I suspect there might be a few of you who are very much Hillsided out by the end of last year, but as Matthew said, we couldn't do a run through of top planning cases without at least talking about it for a bit at the time. So as is now widely known, Hillside is the leading case on successive grants of planning permission which are inconsistent with one another. The scenario is a fairly common one. The first planning permission is granted and then only partially built out. The second permission is then granted for the same site and built out in such a way that the first permission can no longer be completed in accordance with its terms. On the facts of Hillside, planning permission had been granted in 1967 for 401 homes, subject to an approved master plan, which showed where each of the houses were to go and also where the roads across the sites were to be located. Only 41 of the 401 houses were actually ever built, none of them in the location shown in the 1967 master plan. Some of them weren't authorised, and most of them were built in accordance with subsequent planning permissions, which related to only parts of the site. Roads had also been built over places that the 1967 master plan showed as reserved for houses. So the question for the court was, in those circumstances, could the developer still rely on the 1967 permission? That's to say, in effect, could they mix and match between part of the original permission and these other successive planning permissions, which were for only part of the site and inconsistent with it? The clear answer for the Supreme Court was that the developer could not rely on the original permission. And in reaching that decision, the courts applied and affirmed, and to some extent restated, what's known as the Pilkington principle, which is the principle that if there are two or more planning permissions granted, the first can no longer be relied on if, as a result of physical alteration of the land to which the planning permissions relate, it becomes physically impossible to carry out development for which the first planning permission was granted. That's the case even if it's possible to carry out part of the development on part of the site. The key point is that unless there are express words in the first permission which make absolutely clear that parts or phases of the development that have been permitted are severable from one another, the second permission will need to provide a coherent scheme for the whole site. The other important point which the court decided is that if a planning permission isn't built out to completion, and it might be physically impossible to do so, it's not the case that everything that's been done so far becomes unlawful and therefore subject to enforcement action. There's no requirement to implement a planning permission in full, contrary to what seemed to have been suggested in the Court of Appeal. That's something of a whistle-stop tour through a really big and important judgment, and there's lots of points in there that will need further clarification in subsequent case law, particularly on what it is that makes a planning permission severable, and also what are the non-material departures from the original permission that might be permitted on the facts of particular cases. But that's the framework for the analysis that the Supreme Court has laid down for us to all pore over. And I think now Matthew's going to go through the other Supreme Court case, which is DB Symmetry.
Thank you very much indeed, Isabella. Yes, I'm going to now talk about DB Symmetry. This is a case which relates to the grant of outline planning permission for a mixed-use development on the outskirts of Swindon, subject to a number of planning conditions. And this appeal related to one of those conditions. And there were two issues in the case. The first, which was the principal legal issue, was can a planning condition lawfully oblige a developer to dedicate roads within the development as public highways? And then secondly, does the planning condition in this case, correctly interpreted, actually do that? And the answer to the first question is no. The Supreme Court has confirmed the understanding in previous case law and indeed government guidance that a planning condition which purports to require a landowner to dedicate roads on its development site as public highways would be unlawful due to being unreasonable. Instead, the result of dedication of a road can only be achieved by one of two options. The first being what is typically used for this, which is negotiation of a Section 106 planning obligation, or alternatively through the acquisition of the relevant land by the authority, either by compulsory purchase powers or by agreement. And the court, in reaching that conclusion, highlighted there being a fundamental conceptual difference, in the court's words, between a unilaterally imposed planning condition and a planning obligation which can only be entered into by the agreement of the developer. On the second question, the condition was interpreted by the Supreme Court as clearly and sensibly not requiring dedication, but was instead addressed to the quality and the timing of the construction of the roads. And this was found to be a matter of interpretation that was sufficiently clear without there being any need to rely on the rule of interpretation that is known as the validation principle, which some of you may be familiar with, which is where if a document can be read in two different ways, the court should prefer an interpretation that renders the document valid rather than void. But the court didn't even need to rely on that principle here because the language of the condition was regarded as clear on its face. This is a case which will no doubt be useful to practitioners more generally than just dealing with this issue of dedication of roads as highways, in that it contains what I regard to be a helpful summary of the state of the law generally on planning conditions and indeed Section 106 obligations. Over to you, Isabella.
Thanks. And next up is Barton Park Estates, which is a case about a principle that's commonly referred to as the I'm your man principle, which is that where a planning permission authorises a particular use subject to limitations, and that might be a time limit or a limit on the number of hours that the use can be put into effect, that limitation will be invalid unless it's set out in a planning condition, even if expressly stated in the body of the permission. That principle has given rise to some difficulties, particularly because it seems to sit somewhat uncomfortably alongside the modern approach to interpreting planning permissions, particularly the instruction that we should read planning permissions objectively and look at their words as a whole. So on the facts of Barton Park, planning permission had been granted for the description that's on that slide there, on a site in Dartmoor National Park. There was a condition attached to the permission which restricted the number of months of the year that the holiday chalets and holiday caravans could be occupied, but there was no condition prescribing that specific mix of residential and holiday units. That limit was only in the description of the development at the top of the decision notice. The site owner wanted to station 80 caravans, all for permanent residential use, and made an application for certificate of lawful use, which was refused, and that refusal was upheld on appeal. And that's because it was found that the proposal to have all residential accommodation would constitute a material change of use, and therefore fresh planning permission was required. The inspector's decision was upheld when challenged both by the High Court and the Court of Appeal. And in reaching his decision, Lord Justice Lindblom began by reaffirming lots of orthodox principles about how planning permissions should be interpreted, including, as I mentioned previously, that a reasonable, you should take the test of a reasonable reader and how they would understand the words of the permission in context and read as a whole. And in this case, he said that the reasonable reader would not conclude that the permission at issue authorised the use of the site as a caravan site generally, or for a caravan site where all of the units were being lived in full time. He said that a reasonable reader would understand it to prescribe a specific mix, even though that mix was not contained in a planning condition. Lord Justice Lindblom said that he didn't think that that conflicted with the I'm your man principle, because as had been suggested in a previous case called Winchester City Council, that principle does not apply where there's a material change of use. It applies only where there's been a change in the manner of the exercise of the same use. Just to note, Lord Justice Mayles agreed with the result that the inspector's decision should stand, but he gave a separate judgment expressing dissatisfaction with the complexity that I'm Your Man had created. And I think that that's a sentiment with which I am inclined to agree. Now back to Matthew on, I think, interpretation of policy.
Thanks very much, Isabella. I'd have to say, in the whole world of planning law, I have to say that the I'm Your Man principle is the best named principle around, in my view. It's just wonderful how often planning lawyers have to say I'm your man. Right, Thurston is the next one. This is a Court of Appeal judgment all about the important difference between the interpretation of policy and its application. And it also emphasizes, to my mind at least, the importance of carefully reading what a planning policy actually says. It concerned a policy in a neighbourhood plan which did not allocate any sites for housing and said that new development in the parish, quote, shall be focused within the settlement boundary of the village. And the Court of Appeal agreed with planning officers in this case, who recommended approval for the scheme, that the word focused does not mean that there can never be any development outside of the settlement boundary. It's not in such absolute terms. And the court also noted that the plan as a whole recognised the existence of significant housing needs which could not be met within the village boundaries. And the court said that in reality, this is a claim which, like others before it, and no doubt others which will come, raises an issue as to the application of planning policy as opposed to its interpretation. And the court, interestingly, also rejected a submission that in all cases, an officer's report is required to identify precisely which policy or policies a proposal does or does not accord with. That will instead depend on the particular context at hand. There may be certain policies which do need to expressly be dealt with, others which don't. And this is I'm sure, not the only policy in local plans up and down the country, and indeed neighbourhood plans, to use language such as focus in directing the location of development to a particular place, either within boundaries or within other sorts of development constraints. And so it remains to be seen whether this judgment has a bearing on how similarly worded policies might be interpreted and applied in other cases.
Next, we have a case from Newcastle, which is about a permission that was granted for 289 apartments on Newcastle quayside by an inspector on appeal. The local planning authority, which is Newcastle upon Tyne City Council, brought a successful challenge in High Court, and the permission was quashed. I think the most important part of the judgment relates to heritage, because Mr. Justice Holgate found that the inspector had erred in her assessment of the level of harm that the proposal would cause to a Grade 1 listed church. On the facts, HE at the application stage and the LPA at inquiry had concluded that there would be a moderate degree of less than substantial harm to the significance of the church, but the inspector concluded that the harm was at the lower end of the scale of less than substantial. Crucially, one of her reasons for reaching that assessment was that, in her words, there could not be a vastly different design response which could further minimise the harm caused. That's to say, she thought that any other scheme would cause at least the same level of harm. And so there's sort of an element of the inevitable there. That point, Mr. Justice Holgate said, was a legally irrelevant consideration, which meant that the decision needed to be quashed. And he said that the fact that the harm had been minimised told us nothing at all about how much harm there would be. Harm can be minimised but still substantial, or it can be minimised at the upper end of less than substantial. The inspector was required to reach a judgment as to how much harm there would be, and the fact that it had been minimised wasn't relevant at that stage. At least part of where the inspector appears to have gone wrong is in conflating two different paragraphs of the MPPF. The first of them is paragraph 195, which requires that any conflict between a proposal and the conservation of a heritage asset be minimised, and paragraph 202, which requires any less than substantial harm to a designated heritage asset to be weighed against the public benefits of the proposal. Crucially, the word minimise is used in paragraph 195, but it's not part of the first stage of the assessment under paragraph 202, which is working out how much less than substantial harm there is to weigh in the balance against the public benefits. Beyond even 202 and the heritage context, I think that this case provides a really useful reminder of the importance of taking a careful and clear structured approach to analysis in officers' reports and in proofs of evidence on inquiry, because the question of how much harm there'll be will almost always be the first logically prior question before you come on to think about what the significance of the harm is in policy terms, whether the harm has could be further minimised, or whether any particular level of weight should be attributed to the harm. You need to start with the first question first, which is working out how much harm there is in the first place.
Thanks, Isabella. Next case is CPRE Somerset. We've included this case because it's an example of a rare successful claim for apparent bias in a decision by a planning committee to grant planning permission. There are lots of cases which allege apparent bias by decision makers, not just in the planning context, but more generally, but it's actually relatively unusual for them to succeed. The proposed development in this case was for the erection of 5 buildings on agricultural land to store and enable the construction of carnival floats. The application was made by Ilminster Town Council, and the vice chair of the planning committee who determined to grant planning permission was at the time the deputy mayor of Ilminster and a member of the town council. And the chair of the planning committee was a member of the carnival committee, in which capacity he publicly supported the application, and was also a close affiliate of the agent for the applicant. They declared their personal interests at the meeting of the planning committee. And that was done so under the member code of conduct, but on the advice of the monitoring officer, they took the view that they did not have what was referred to in the code of conduct as a prejudicial interest, which would have precluded them from participating in the meeting. So therefore they did participate in the meeting, and they voted in favour of granting planning permission. And it was I think a bare majority of 1, which enabled the permission to be granted by the committee. The judge, Mr. Justice Chamberlain, helpfully reviews the authorities on apparent bias and identifies the test as being whether the fair-minded and informed observer would conclude that there was a real possibility that the committee was biased. The judge noted case law to the effect that where the decision maker is himself a party to the proceeding, he is automatically disqualified on the grounds of apparent bias. And he cited, for example, the General Pinochet case where Lord Hoffman was sat on the bench in the House of Lords, but was also I think on the board of trustees of Amnesty International, who had campaigned vigorously in relation to this case and also was an intervener in the proceedings. Anyway, going back to Somerset, the judge found that there was a real possibility of bias on the part of the vice chair. He was one of 15 members of the town council and had been present at the meetings where support for the application was expressed. He also found that the long-standing association of the chair with the Carnival Club, which indirectly depended on the application for continued financial viability in the medium term, was enough to give rise to apparent bias too. But what I think is a nice touch, I think, from the judge is the final paragraph of the judgment, where the judge clarifies that this outcome does not reflect adversely on the integrity or professionalism of either councillor. Both councillors declared their interests openly, neither attempted to hide their associations, both followed the advice of the monitoring officer, and that advice flowed from the officer's honest analysis and application of the code. The monitoring officer went wrong in law, as many public decision makers and most judges do at some point, but was not otherwise at fault. So I thought that was actually quite a remarkable thing for a judge to say, just to emphasize that there wasn't any deliberate wrongdoing, so to speak, in this case. And I'm sure that could be said for many of the planning cases that we come across in our practice.
Thank you. And now this case, the Wyatt case, is about something of a hot topic over the last few months in particular, and that's nutrient neutrality. I just wanted to mention that there is going to be a specific landmark webinar on nutrient neutrality and house building on 6th of February. So if you wanted a fuller explanation of how things are working, then you can maybe join that. But just on the Wyatt case, the LPA on the facts had granted planning permission for 8 houses just over 5 kilometres from the Solent and Southampton Water SPA. The chair of a local residents group, Mr. Wyatt, sought to challenge the grant of permission on habitats grounds, and his claim was dismissed by Mr. Justice J, and then that decision was upheld by the Court of Appeal. So crucially, it was a challenge to the grant of planning permission, but in the course of his challenge, Mr. Wyatt sought to argue that technical guidance on nutrient neutrality given by Natural England was legally flawed. And the case focused in particular on guidance given in relation to the methodology for calculating a nutrient budget for development which will drain to the mains network. In rejecting Mr. Wyatt's challenge, Lord Justice Lindholm gave a number of I think useful pieces of guidance for local authorities in particular. Quite a few of them, there were 3 that I wanted to draw out in particular, which I think are quite generally applicable. The first is that whilst an appropriate assessment under the Habitats Directive and regulations must be based on best scientific knowledge, and that's a requirement that comes from earlier case law, this doesn't mean that every individual figure in the assessment must itself constitute best scientific knowledge. We're told that the courts will take a holistic view of the overall methodology and not sort of go through each and every number with a fine-tooth comb. The second point is that there's nothing objectionable in principle about the use of average figures. Whether or not an average provides sufficient certainty will be a matter for the authority to determine. And thirdly, there's no requirement for every element of the methodology to be based on algorithm or arithmetic. On the facts, a percentage buffer based purely on judgment had been applied, and that was acceptable. So clearly, I think the judgment does give quite a bit of room for manoeuvre for LPAs, particularly where, as on the facts of Wyatt, Natural England had been consulted and hadn't objected to the approach taken. And that clearly gave quite a bit of security on the facts.
So that's Wyatt, and that's about habitats. We're now going to talk about Finch, which is another environmental case, this time about EIA, Environmental Impact Assessment. It concerns a judicial review of the grant of planning permission for 4 new oil wells on a site in Surrey to produce hydrocarbons over a period of 25 years. And the basic question in the appeal was whether it was unlawful for a planning authority not to require the EIA for the oil extraction project to include an assessment of the so-called downstream impacts of greenhouse gas emissions that would arise inevitably from the eventual use of the refined products of oil as fuel, typically in road vehicles. And it was common ground that any extracted oil would need to be refined, and that the refinement and eventual end use could take place either in the UK or outside of it. The Court of Appeal said that the question of whether any particular impact, including the impact in this case, is truly a likely significant effect for the purposes of the EIA regime that needs to be included with an EIA for a particular development is ultimately a matter of fact and evaluative judgment for the authority. It's not a question of law. In determining the direct and indirect effects of a development, what needs to be considered is what the court identified as the necessary degree of connection between the development and its putative effects. The local authority in this case had exercised their judgment to conclude that the emissions arising from the end use of the combusted oil were not effects of the development specifically, and 2 of the 3 Court of Appeal judges were satisfied that the reasons they gave for this were legally adequate, and 1 judge disagreed by dissent. And the case has very important implications for how to approach in an EIA the less direct and obvious impacts that might be said to flow from a particular development. In many cases, there will be it will be clear that certain effects are effects of the development that need to be assessed, but some others are borderline. And this case is all about those difficult cases, those cases that are in the margins. It speaks more widely also to the proper role of the planning system in regulating greenhouse gas emissions. And as we will shortly be discussing, this case is off to the Supreme Court in June of this year, and so is one of the ones that we're going to be inviting you to keep an eye on.
And back to another habitat case, this time the Harris case is in the Norfolk Broads. In this case, the Environment Agency had been investigating the effects of the abstraction of groundwater, including by farmers in the Norfolk Broads, and their investigation was limited to only 3 of the 28 sites of special scientific interest, SSLHCs, that together make up the Broads Special Area of Conservation. The claimants who live in the Norfolk Broads challenged the EA's refusal to expand the investigation to the whole of the SAC, so all 28 sites rather than just the 3. Their claim was successful, and the EA was ordered to formulate a plan as to how it intends to discharge its legal obligations within an 8-week period. The key point is that Mr. Justice Johnson found that the EA had failed to comply with Article 6.2 of the Habitats Directive, which provides that where there is a risk of deterioration of a protected habitat, appropriate steps must be taken to avoid that deterioration. The EA had discharged that obligation in respect of the 3 SSSIs it was investigating, but not in respect of the rest of the SAC, so the other 25 sites. Now, of course, the Habitats Directive is an EU instrument, and it wasn't entirely clear whether all of it continues to apply post-Brexit. And Mr. Justice Johnson held that Article 6.2 does continue to be enforceable in UK law after Brexit under Section 4 of the Withdrawal Act, because in the words of the statute, it imposes obligations of a kind recognised as being available in domestic law before the transition period came to an end. Now, the Withdrawal Act is a really important piece of constitutional legislation which governs the relationship between UK and EU law post-Brexit. It surprised me how long it's taken for many of the important and difficult questions as to its meaning and effect, and how long it's taken for those issues to come through the courts. And Harris provides clarity on at least one of them, which is what it means for a directive to impose obligations of a kind recognised. And the key point in Harris seemed to be that the Court of Justice had recognised that Article 6.3 had direct effect, and there was a close relationship between that provision and Article 6.2. And therefore Article 6.2 continues to be enforceable as well. That's an important point, I think, significant not just for the Habitats Directive or indeed environmental directives, but for all EU directives which are applicable in all fields.
The last case we're going to talk about in any detail is Ipswich, and this is a case of 2 conjoined claims by different local planning authorities seeking interim injunctions, trying to stop hotels from being used to accommodate destitute asylum seekers pending the determination of their claims for asylum in the UK. The context is that the Home Secretary has a duty to provide temporary accommodation to an asylum seeker pending determination of their claim. And there is firstly the initial processing of their claim, during which they're provided with what's known as initial accommodation, after which they're then moved to what's known as dispersed accommodation, where they will remain until an asylum decision is made. And the short problem for the Home Secretary is that they don't have enough accommodation without needing to rely quite significantly on private hotels to accommodate asylum seekers during that period. And the local authorities in this case alleged that the so-called block booking by service providers that were acting as agents of the Secretary of State of the 2 hotels in question for the purposes of providing initial accommodation, they say that resulted in a material change of use from the lawful use class C1 hotel use to an unauthorized sui generis hostel use. And they sought injunctions to restrain what they regarded as a breach of planning control. And they asked the court for these injunctions to be imposed immediately and pending the final determination of their claim of a breach of planning control. And while the initial injunctions were granted by the court without notice to any of the defendants in late October 2022, the matter came before the court in early November as a return date before Mr. Justice Holgate, who dismissed the applications to renew the injunctions until the trial. The judge found that there was a triable issue as to whether there had been a material change of use from hotel to hostel, but that he saw the urgent need for contingency accommodation to house what would otherwise be destitute asylum seekers pursuant to a statutory duty imposed on the Secretary of State was an important consideration. And moreover, discharging the injunction pending the trial would not cause significant planning harm in the meantime. And as we'll come on to mention in a moment, this is not the last of the hotel asylum accommodation issue, because there are other cases afoot.
And we did try our best to keep it to just the top 10 cases, but these are just 4 to mention much more briefly as of interest too. So the top one on the list, the Smith case, I thought was particularly interesting in terms of remedies that the court might grant. So that was a challenge to refusal of a planning application. But in the course of the judgment, it was found that the policy that had been in place since 2015 on gypsy and traveller sites was unlawful, and that was the basis for quashing the inspector's decision. The second case, Gardner, just I think a practically important one, which is that the SIL exemption for self-builders doesn't apply where they're developing under a retrospective planning permission. The third one is the quashing of the Holocaust Memorial Permission. The reason that the permission was quashed was very limited. It was to do with the London County Council Improvements Act 1900, which I think is unlikely to keep on cropping up in other applications. But there is some useful guidance in the judgment about the meaning of the word substantial in the NPPF in the context of substantial harm to heritage assets. And the court reminds us that that word just means what it says. There's no extra gloss or extra test, such as draining away of significance or otherwise. And then the last case on the list is about the public sector equality duty as applied in the context of an order for low traffic neighbourhoods. I think there's lots in there that's really useful, particularly for public authorities thinking about how they can discharge that duty, both in terms of what's required and what's not required, because the court really emphasises that the public sector equality duty doesn't prescribe any particular result, and it also doesn't prescribe any particular procedure. You don't have to follow a particular format of equality impact assessments, for example, although of course those will be useful. I think we're ready then for 2023.
Yes, thanks very much, Isabella. So then the last thing we're going to do is just run through a couple of the cases that we're aware of that are coming up in 2023. I'm sure there are others which we're not aware of, but these are just some of the ones to keep an eye on. The first is Finch, as we mentioned earlier. The Court of Appeal handed down their judgment last year, and the original claimants, now appellants, have been granted permission to appeal to the Supreme Court, and it's listed for 2 days in June 2023. There are pending applications for permission to intervene in the proceedings by Friends of the Earth and also Greenpeace. Secondly, there is a legal challenge to the Sizewell C nuclear power station development consent order, which was granted by the Secretary of State in July last year. It's listed for a 2-day rolled up hearing in March 2023. The key grounds relate to alleged breaches of the habitats regulations and also an allegation of inconsistency between the project and the UK's ability to meet its climate change obligations. And this is not the only significant environmental challenge coming up, because we also, I'm sure many of you will remember, shortly before Christmas last month, the Secretary of State granted planning permission on a called-in application for a new coal mine near Whitehaven in Cumbria, which has generated significant controversy over whether the decision is consistent with the government's climate change obligations. And on the 4th of January, i.e. a week ago, Friends of the Earth announced its intention to issue a legal challenge to the decision. So that will be coming up later this year as well. Next, in an appeal decision, some of you may be familiar with this, in an appeal decision that was issued in November 2022, contrary to legal arguments that were made by the developer, a planning inspector determined that Brexit has not altered the law in respect of habitats regs appropriate assessments that are taken at the reserve matters or discharge of conditions stage. A subsequent need for appropriate assessment at this later stage was found by the inspector not to be inconsistent with the principle that an outline permission establishes the principle of the development in question, and that all that matters at the condition stage and the reserve matter stage is what is required by those conditions. So the multi-stage approach for habitats assessments for now remains good law, but this appeal decision has been challenged by the developer CG Fry. I think the claim was issued last week, in fact, so this is an important case to keep an eye on in the coming months. Next is this issue of the hotel or hostel asylum accommodation. So I think we still have the substantive trial of the Ipswich injunction, which is yet to take place. And there are other cases that I'm aware of raising similar issues. Torbay Council have brought a claim for judicial review against the Home Secretary for making use of a hotel in Torquay to house asylum seekers. And there are, as I understand it, other local authorities threatening similar claims at the pre-action stage. So there's more to come in relation to that. And I'll now hand over to Isabella to cover the last 3 bullet points.
Thank you. So the last 3, Day and Shropshire Council, is a case that was heard before the Supreme Court just before Christmas, and that's to do with statutory trusts and public recreation rights over land and how that should be factored into planning applications. The second one at the end there is NHS contributions, and particularly the issue which I've seen cropping up quite a lot in the last few months, which is NHS Section 106 contribution requests, which are not for kind of physical infrastructure like new wings of hospitals, but for the costs of providing NHS services to additional patients moving into new housing developments. There had been a case on that recently, but it was settled before there was a judgment. But a case from Leicestershire was heard by Mr. Justice Holgate just before Christmas. So hopefully a judgment on that at some point in the first part of this year. And then finally, of course, it looks like there's going to be a new MPPF. And as with all the iterations before, the interpretation of that will no doubt give rise to litigation. Presumably we'll start, if a new MPPF is adopted, we'll start seeing that at some point later this year and 2024.
Thanks very much, Isabella. So that's the end of the formal part of the webinar, and we're now going to attempt to answer some of the really good questions that have been asked by participants throughout the course of the last 45 minutes. I think we've just got a couple of minutes, Isabella, so I think if I'll maybe take 1 or 2 and then over to you if you want to pick up on a couple, and then anything that we haven't covered, then please do get in touch with us. There's a question for me all about the Highways Act and provisions in the Highways Act in connection with DB Symmetry. And I think essentially the question is, well, can authorities still rely on, and developers indeed still rely on, provisions within the Highways Act for securing dedication of roads? And the answer is yes, they absolutely can. I think that this case was more about how does that requirement to enter into an agreement under the Highways Act need to be secured, and it can't be a requirement in a planning condition to enter into an agreement like that. But obviously, as is typically the case, a Section 106 agreement can require a developer, assuming that they enter into an obligation, to reach agreement with the Highways Authority under the provisions of the Act. So that's how they would do it. And then there's also a couple of points raised about Ipswich, the case of Ipswich. One question is, did the asylum seekers' human rights form a material consideration in their destitute situation? I'm sure they did. And I suspect it was one of the factors which motivated the judge to find that there was essentially quite a compelling reason to enable this form of accommodation to continue pending the trial, in line with the fact that the government had this statutory duty to house them, which is a reflection of the fact that they have human rights and they need to not be in a destitute situation. So I think that's how it fed through into the judgment. Very helpfully, someone has anonymously informed us that the Ipswich case has in fact been discontinued, so there won't be a substantive hearing. But obviously that doesn't avoid the fact that there are, as I mentioned, some other pieces of litigation, shall we say, which are raising similar sorts of issues. There's a point quickly about apparent bias and whether there's a time limit on bringing a claim for apparent bias against a council. The answer to that will be that the general time limit for bringing a challenge, that's assuming it's to do with a determination of a planning application, then the time limit will be the time limit that applies for all judicial reviews, namely 6 weeks from the date of the decision. So that's I think everything that I'm able to cover. But Isabella, is there anything that occurs to you that you might be able to respond to?
I just try to answer a couple really quickly. I'm conscious that we've kind of gone past the quarter to time limit. I can see someone had asked for more information on the NHS case, and I think probably would have been helpful for me to say the name of the case, and that's University Hospitals of Leicester NHS Trust and Harborough District Council, and that's a challenge to the LPA's refusal to impose that kind of contribution in respect of a big strategic development in Lutterworth, but hopefully would have a proper case reference when there's a judgment in due course. And then I could see one question about, I assume about Hillside, about why the first consent didn't expire naturally because of time expiry conditions. I think that probably is worth just emphasising one aspect of the unusual facts of Hillside, which is that there had actually been earlier proceedings in the 1980s where the judge had, amongst other things, confirmed and given a declaration that there had been development implementing the original permission. So some things had been done, albeit not putting houses in the right place. So the permission was extant. Then I think someone had asked if there'll be a recording available after the session. I think that will be on the website and on the YouTube Landmark YouTube
that will be done.
Channel. Yeah,
I think there'll be an email that goes out to everyone who's registered their details with a recording. So that will be the way in which it's provided. So I think with that, we might draw things to a conclusion because we've gone a few minutes over our allotted time. But just to reiterate how grateful both Isabella and myself are to everyone for coming this morning and starting the new year with a recap on what was happening last year and what interesting things are yet to come. Apologies to anyone whose questions we haven't been able to answer. If you want to get in touch with us by email, please do so. We'd be happy to discuss. And with that, I'll bid everyone a good morning.